Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers assault, identifications, and probable cause arrests, and is brought to us by All Trendy News' channel. Be sure to check out the description below and give them the credit that they deserve. On April 7th, 2021, two officers from the Sunset Valley Police Department responded to a call at a Nordstrom Rack store in Sunset Valley, Texas, after employees reported that Lake Travis School Board candidate Cara Bell shoved an employee and forced her way into a dressing room after an altercation regarding the store's policy. Upon arriving, the officers approached Ms. Bell outside of the establishment and began to question her about the incident.
You did say I had to have an ID to be here.
No, we need that. You need to give
Didn't
us
you say?
identification.
Okay.
Was the call taker able to get a last name? She's refusing to identify herself.
It's my God-given right to be here on this planet, and you cannot tell me otherwise. Correct? You just lied to me.
I lied to you about what?
You said I had to have an ID to be here.
No, you got
That's
to
not what I
identify
said.
yourself.
When you're legally detained, you can play back on your video. When you're legally detained, you have a duty to identify yourself to a police officer.
Okay, so they're saying when I'm legally detained, which I was not, that I have the
Can you try to run her without a date of birth? White female, approximately 40, 45 years of age.
How am I legally detained? Can you?
We were called here to investigate after I was shoved. Okay, so they're saying
And I called
that,
you too.
Okay, so let me
I called the police too.
Are
but
you
they're
going to let
only
me talk, or are you going to be the
employee
only one
of Nordstrom
talking?
Rack?
Because right now, as a call taker, I know you want to have them on there for your safety purposes.
Yes.
But right now, you and I need to be talking, not them.
Says who?
You need to continue having a conversation with me. So,
Because?
you said that she shoved you.
She
You want to
did.
file assault charges. She's saying you shoved her, and she has witnesses. You have witnesses to say that she shoved you.
She has the manager?
No.
No. Okay.
There are other
Well,
employees that were
I
in the
would-
fitting
I
room.
would-
Although Ms. Bell alleges that the Nordstrom Rack employee shoved her, the officer explains that the employee claims Ms. Bell is the one who did the shoving, and that she has witnesses that will back up her side of the story. Under Section 22.01 of the Texas Penal Code, a person commits assault if the person intentionally, knowingly, or recklessly causes bodily injury to another, threatens another with imminent bodily injury, or causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. Because Section 1.07 of the Texas Penal Code defines the term bodily injury as, quote, physical pain, illness, or any impairment of physical condition, a push or shove without pain or other impairment likely would not classify as assault under the first part of the statute. However, the action would probably be covered under the provision prohibiting, quote unquote, offensive or provocative physical contact. In the 2011 case of Gomez versus State, the Texas Court of Appeals reviewed a case where an individual pushed another aside in an attempt to get past him. The court stated that, quote, the assault occurred when appellant attempted on 2 or more occasions to go past into the house when the defendant shoved and pushed the victim. As in the Gomez case, the Nordstrom Rack employee alleged Ms. Bell repeatedly pushed her before shoving her, and if this is true, it is likely that her actions constituted assault. However, in a trial, the judge or jury must weigh the credibility of competing testimony and can only find the individual guilty if they believe the state has proven beyond reasonable doubt that they committed the offense. In the 2009 case of Foster versus State, the 14th District Court of Appeals of Texas affirmed a conviction for murder that hinged on the contested testimony of a single individual. Although the defendant argued that the witness's testimony was unreliable because of inconsistencies, the court noted that, quote, the testimony of a single eyewitness is sufficient to support a jury's verdict, and that, now quoting again, conflicting testimony does not destroy the sufficiency of the evidence. Rather, the court explained that, quote, contradictory evidence affects the weight of the evidence and a witness's credibility, and that a fact finder, such as a judge or a jury, quote, may judge the credibility of witnesses and may choose to believe all, some, or none of the testimony presented. Accordingly, if a fact finder determined that the Nordstrom Rack employee's testimony was more credible, Ms. Bell could be found guilty of assault despite her claims that she was the one assaulted.
Okay, other employees? Well, there's also another woman without a mask. Isn't that interesting how she only picked me?
Well, I have nothing to
She
do
only
with that at
picked
all.
me, the white person, not the black person wearing a mask. Do you think it's a racist thing? I don't know.
We're not here to talk about race.
Well, you know what?
At
It
all.
kind of seems like it's a racist thing when the black woman doesn't have a mask on, but she comes after the white woman. That's the only
Okay,
difference.
so that's
We're both
something where you would
women.
file a complaint with Nordstrom Rack.
Okay, but I also want to file a complaint with you for her assaulting me.
Okay,
by
and she
shoving
also
me.
wants to file assault charges
Okay,
against you.
okay.
Do you have a middle name?
Do you have a middle name?
Yeah, my name is Gene.
What is it?
Really think that's a
Jean?
negative.
Do you have a
First
middle
name?
name?
White female,
R.
approximately
Jean Eller?
5'8",
Do you have a, do you have a middle
5'10".
name?
Why is it your business?
Because we have to identify you. If I can't identify you, I'm taking you to jail.
Okay, this is
Okay.
getting weird. Now they're saying if they can't identify me, they're taking me to jail. How do you identify the homeless?
That's
Huh?
a
They
negative.
tell us their names, their date of birth. They work with us.
Are
You're
you able
not
to look
working
up
with us here.
anything
Working
or
with you, I
reverse
was
check
just
on the
assaulted
cell
at
phone
a
number
store
that
for
you
not
But we
doing
can't
anything
get to
wrong.
that. Well, we can't get to that point. We're not on either side. We don't know what's
You
going
are,
on
you
because
are
we can't
taking
identify
sides.
you.
You are taking sides.
No.
Robert Eugene Eller, you are taking
Not
sides.
Eugene.
Robert Gene Eller, you are taking sides.
I'm not taking
and it's
sides.
really sad.
Listen.
It's really sad.
We're trying to get information from you, but we can't even get any information from you.
This happened at Nordstrom Rack.
Ma'am, you need to stand over
Ma'am, you
here.
can't leave because right now you're still detained.
Oh my God. I can't do it now.
No, you can't. You are being detained.
Why am I being detained?
Because
Please.
we don't know who you are.
Okay, I'm being detained because they don't know who I am.
Okay?
Which
We were called
apparently
here.
is illegal.
We were called here for a situation, okay?
A situation where I was.
Which
pushed
we're
by
We
investigating.
don't
So if
know.
you are a
We're
victim-
investigating it.
Okay, where's the investigator?
If you
are you
are-
an investigator?
Ma'am,
We are officers. We
Kara,
have to figure
Kara
out what's
Bell.
going on.
if you're a victim of assault, we need to know who you are.
Ms. Bell repeatedly refuses to identify herself to the officers, even though they tell her that she's being detained. In the 2004 case of Hybel versus Nevada, the Supreme Court held that state statutes requiring a suspect to disclose their name in the course of a valid Terry stop are permissible when they are consistent with the Fourth Amendment. However, Texas does not have such a statute in place. Section 38.02 of the Texas Penal Code states that a person commits an offense if they intentionally refuse to give their name to a peace officer, quote, who has lawfully arrested the person and requested the information, or if they give a fictitious name to a peace officer who has, quote, lawfully detained the person or requested the info from a person that the peace officer has good cause to believe is a witness to a criminal case. In this situation, there is nothing to indicate Ms. Bell was under arrest at the time of her refusal, or that she gave a fake name to the officers, and she had no legal obligation to identify herself, despite the officers' assertions otherwise. However, the officers almost certainly had reasonable suspicion to detain Ms. Bell and investigate the incident further, despite the fact that they had not personally observed any suspicious behavior on her part. As we have discussed many times before here on ATA, and as the Supreme Court noted in the 2014 case of Navarrete versus California, quote, the Fourth Amendment permits brief investigative stops when a law enforcement officer has a particularized and objective basis for suspecting the particular person stopped of criminal activity. The court then went on to explain that reasonable suspicion, quote, is dependent upon both the content of the information possessed by police and its degree of reliability, and to clarify that, quote, we have firmly rejected the argument that reasonable cause for an investigative stop can only be based on the officer's personal observation, rather than on information supplied by another person. Similarly, in the 2005 case of Brother versus State, the Court of Criminal Appeals of Texas rejected an argument that an officer must personally witness facts giving rise to criminal activity in order to detain an individual, reasoning that, quote, the federal courts and our lower Texas courts have consistently held that a stop based on facts supplied by a citizen eyewitness, which are adequately corroborated by the arresting officer, do not run afoul of the Fourth Amendment. In this situation, although it is impossible to know what actually occurred in the Nordstrom Rack dressing room, multiple witnesses reported that Ms. Bell pushed and shoved one of the employees. Accordingly, a court would most likely conclude that the eyewitness statements provided the officers with at least sufficient reasonable suspicion to detain Ms. Bell for a brief time to investigate the incident further, if not probable cause to arrest her.
Carabelle, how did you know my name was Carabelle?
Because I heard you say it. You said it on the phone when you called 911. That's how I know.
You just called and got it. Don't lie.
No.
You are lying to me. I just heard you call the police officer that I talked to and get my name. Now you're
It's not
lying.
a police officer on the phone.
Now
When
you're
you were
lying.
in the fitting room.
You
I
are
heard.
lying. Stop. This
Okay.
is the second time I caught you in a lie.
Okay. Replay your video. I'm not
Okay.
lying.
Okay.
Making the situation worse.
No, you are. By not following the law. First of all, I don't have to identify myself.
Yes, you do.
Actually, I don't. It's called common law. You should read up on it. I do not. Okay? So we both know that I don't. I am a woman of God. This is my right as much as it is yours. This is my land as much as it is yours. I did not sign up for this. I am a Christian woman of God, and you are not going to put your disgusting rules on me that are false and not true. I will not have it. You understand that? I will not have it. I'm sick of being bullied. I'm sick of being lied to, and it's not going to happen anymore. Do you understand? The CDC just released...
Turn around.
Oh my gosh. Oh my gosh.
Play this game.
Oh my gosh.
While arguing with the officers, Ms. Bell takes a step toward them, and the officers place her in handcuffs. Article 14.03 of the Texas Code of Criminal Procedure permits peace officers to arrest without a warrant individuals found in so-called suspicious places under circumstances that reasonably show that they have been guilty of a breach of the peace. It is highly likely that the alleged assault constituted a breach of the peace, as the Court of Criminal Appeals of Texas determined in the 1948 case of Woods v. State that a breach of the peace occurred when one person assaulted another in a public place in the presence of others. However, it is less clear whether the Nordstrom rack constituted a so-called suspicious place that would authorize the officers to make a warrantless arrest under state law. In the 1986 case of Johnson v. State, the Court of Criminal Appeals of Texas noted that, quote, few, if any, places are suspicious in and of themselves. Rather, additional facts available to an officer, plus reasonable inferences from those facts in relation to a particular place, may arouse justifiable suspicion. The same court explained in the 2003 case of Dyer v. State that, quote, the determination of whether a place is a suspicious place is a highly fact-specific analysis, and that while several different factors have been used to justify the determination of a place as suspicious, the fact that the time frame between the crime and the apprehension of a suspect is short has consistently been recognized as an important consideration. Likewise, the First District Court of Appeals of Texas stated in the 2002 case of Goldberg v. State that, quote, a place can be suspicious because an eyewitness or police officer connected the place to the crime, or because, quote, a crime occurred there, or the police reasonably believed a crime occurred there. So even though the definition of a suspicious place is far from clear, given the way courts have interpreted the term, it is certainly possible that a court would conclude that the officers were permitted to arrest Ms. Bell without a warrant under Texas law. However, even if arresting Ms. Bell would be a violation of the Texas Code of Criminal Procedure, it is highly likely that a court would still find such an arrest to be constitutional. In the 2008 case of Virginia v. Moore, the Supreme Court determined that police officers did not violate the Fourth Amendment when they made an arrest that was based on probable cause, but prohibited by state law. While the Moore case involved a situation where the officer personally observed the offense in question, in the 2008 case of U.S. v. Lopez, the Fifth Circuit Court of Appeals, which has jurisdiction over Texas, applied the Supreme Court's holding to a misdemeanor offense that occurred outside of the arresting officer's presence, stating that, quote, we have not been shown any basis to conclude that the Constitution prohibits an arrest based on probable cause when the cause is a sufficient report of a misdemeanor unobserved by the arresting officer. Although the officers did not state that they were placing Ms. Bell under arrest, and it is unclear whether making an arrest was their intention when handcuffing her, they likely had probable cause to arrest her on suspicion of assault based on the testimony of the multiple witnesses, which means that a court would likely conclude that an arrest under these circumstances would be constitutional. According to a news story on the incident, the officers detained Ms. Bell on the ground to put her in handcuffs while she allegedly pulled away and shouted to other people in the area. They ultimately released her after issuing her a citation for assault, which is a Class C misdemeanor punishable by a fine of up to $500. But the results of her case could not be confirmed through court records. A local news station reached out to Ms. Bell for a comment, but did not hear back, and it is unknown whether Ms. Bell filed a complaint or intends to pursue legal action. Overall, the Sunset Valley officers get a C+. Because although they maintained a professional and respectful demeanor throughout the encounter, they also demanded that Ms. Bell identify herself under threat of arrest when she was not legally obligated to do so, and demonstrated a fundamental misunderstanding of when Texas law permits them to identify citizens. Although police officers are always authorized to request that someone identify themselves as part of an investigation, absent a state law criminalizing the failure to do so, officers cannot threaten to arrest someone for refusing to identify, and the Sunset Valley officers crossed this line in this interaction. However, the officers likely did have probable cause to arrest Ms. Bell for assault based on the testimony of the Nordstrom Rack employees, and courts typically uphold arrests as constitutionally reasonable whenever probable cause exists. Ms. Bell gets a B- because while she maintained a hostile and condescending demeanor throughout the interaction, she refused to identify herself when she was not legally obligated to do so, even after the officers incorrectly informed her that she had a duty to identify herself. It is important to note that I have not considered Ms. Bell's actions in the Nordstrom rack as part of this grade, as I have no way of knowing what actually occurred, and her grade is entirely based on her conduct during her detention. That being said, some of Ms. Bell's statements during her detention seem to indicate that she believed herself to be above the law, and I cannot endorse the entitled attitude that she demonstrated during this encounter. I would encourage Ms. Bell to continue to learn more about her constitutional rights and their limitations by conducting research using reputable legal sources. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.